Mr. Gordon?
May it please the Court. I'm Joshua Gordon. I represent Bobby Dean Freeman, who served the letter of his sentence. Mr. Freeman's sentence is crystal clear from the minimus, from the judge's tongue at the pronouncement on the state's proposed sentencing form, from the prosecutor during the sentencing hearing, and in letters from both to Mr. Freeman from both the Corrections Department and his attorney at the time. They all repeat identical language. Probation is, quote, effective upon release from parole. It means what it says. There's no ambiguity, and Mr. Freeman requests his sentence be imposed as plainly written. The state manufactures an ambiguity where there is none. In order to interpret Mr. Freeman's punishment any different from its plain language, one has to stray from the words. You have to add them or change them. The court below says it focused on a portion of the phrase upon release, thereby truncating from parole.
Well, also the word consecutive, unless I've misread this, correct?
Oh, they're consecutive, absolutely.
Okay.
I don't think that changes the analysis. The state below suggested changing the phrase from upon release from parole to upon release from prison. In its brief, the state suggests changing it to something like upon the end of the maximum term.
Well, everybody assumed that he would actually be paroled, right?
Oh, my client not necessarily assumed that. I don't think that's a justified assumption.
At the beginning?
There's just nothing in the pardon?
Well, he tried to get paroled. He tried to get through the program, right?
Well, he certainly signed up for the SOP twice, but he never applied for parole. But that doesn't betray an assumption at the time of sentencing that parole would automatically happen or that he would successfully complete it.
You misapprehend me. At the time he was sentenced, everybody was probably operating under the assumption that he would at some point be paroled. I think that supports your argument.
Well, it may have been the assumption, but there's just nothing in the record to support it.
What's in the record to support a contrary inference?
There's nothing in the record at all. The only thing we have is the language of the court, created by the state, written by the state, told by the prosecutor to the judge. The judge repeated it both in the transcript and on her minimus. Mr. Freeman twice entered the SOP with good intent, but he found after a while he couldn't in good faith complete it, and then he reviewed his sentencing documents. And his understanding of the consequences of not completing the SOP were that he would not ever get parole. And he made it a reasonable assessment of the sentencing documents. Either he would get a longer term with lesser state control or a shorter time with more intense state control.
Did he testify to this?
Absolutely not.
Where is it coming from then?
I think that's the only plausible assumption one can make from.
If he thought about it, we don't even know if he thought about
it. There's nothing on the record to suggest he thought about it. Never having been on parole, nonetheless, upon release from parole, the triggering event never occurred. By maxing out, Mr. Freeman served his sentence to the letter, and the state claims instead that there's some spirit that he violated, but for proof of the spirit, all they can point to is their assumption that he their assumption of what his thoughts were at the sentencing and the fact that he maxed out, which is obviously not in dispute. If somehow the sentence is ambiguous, then the rule of lenity applies. And lenity regarding statutes has been plainly abrogated by our penal code, but lenity regarding sentences, the code does not bar that, and this court applied it in State v. Rao. The state may argue that criminal sentences are to be construed like commercial contracts, as a handful of states have done, but that is not the law in New Hampshire, and if it is, there's no ambiguity here, and certainly not enough to ignore the minimus or the judge's words.
If he violates probation now, what can happen to him?
Same thing, anything like a normal probation violation. He would
He's subject to the maximum penalty? I mean, he served his sentence, and did he get probation on a different offense?
It's a new offense.
Okay.
It's akin to a new offense.
Thank you.
The other thing is, if we are arguing today, as the state seems to suggest, about what the sentence construction generally, and what the terms are of it, then this case probably shouldn't be on the 3JX docket. The state may also argue that there was a mistake in the sentence, but the sentence is plainly, perfectly reasonable as written. Mr. Freeman either would get a longer term with lesser state control or a shorter time with more intense control. And it is possible that there's a mistake in the state's drafting, but there's nothing in the record to suggest it was a mutual mistake.
Who should have the burden of proof here? That's what I'm thinking.
Given that the sentence is so plain, I think the state's got to have a burden of proof to show that it's different than the plain language of the minimus. I see my time's up. I'll step down.
Thank you.